Further hearings in the appeal, John Wilson against Royal Bank of Scotland and Francis Wilson against the Royal Bank of Scotland.
Mr McCormack.
My Lord, my Lady. I'm conscious that the issue which was touched upon in my closing submissions yesterday, that is to say the interplay between sections 24 and 21 of the 1970 Act, is one which your Lordships and your Ladyship will wish me to address them on, clearly as being, I think, one of the critical issues in this appeal.
Yes.
However, if I may, I propose first to attempt to clear the ground around that issue by making what I hope will be relatively brief submissions under the other chapter headings which I outlined at the beginning of my submissions yesterday. So if I may conclude my submissions on the first chapter, which is the statutory background, perhaps I could simply refer briefly to the consequences of the Homeowner and Debtor Protection Scotland Act 210 having come into force on the 30th of April, because I understand that your Lordships and your Ladyship may have had an opportunity to consider the terms of that statute. And if so, they will have seen that where the security subjects are residential, then by Section 1 of that Act, a creditor who has served a notice of calling up under Section 19 of the 1970 Act cannot exercise the power of sale or of entering into possession, and a creditor who has served a notice of default under Section 21 of the 1970 Act cannot exercise the power of sale unless either they have now applied to the court for warrant under Section 24 of the Act, or in terms of the new Section 23A, the property is unoccupied, and each of the following persons has in writing certified that they believe the property to be unoccupied and that they consent to the exercise of the creditor's rights in default, those persons being the debtor, the proprietor, if not the debtor, any non-entitled spouse. I'm not sure, I have to confess, if that's a term used in English legislation. It simply refers to a spouse who is not a joint owner of the property and is occupying with a spouse who does hold title, and any cohabitee with occupancy rights.
Well, spouses have occupancy rights in Scotland as they do in England, do they not?
Yes, my lady. I was simply indicating I wasn't sure if the term non-entitled spouse was the term which is used in English legislation, and if not, simply indicating that is the spouse who does not have title.
Sounds like it's going to be pretty difficult to exercise these powers.
Indeed, my Lord, as Lord Roger indicates, not only because of the requirement of producing certification to that effect or going through the court, but also because by sections 2 and 3 of the 2010 Act, a creditor who intends to apply to the court for warrant under section 24 of the 1970 Act, or to raise proceedings under section 5 of the 1894 Act, must, before doing so, comply with a new pre-action protocol introduced by the new section 24A of the 1970 Act and section 5A of the 1894 Act.
Well, fortunately, we don't really have to say anything very much about this because we're dealing with the original system.
Yes, your Lordship and your Ladyship fortunately don't require to engage with those new provisions, and I'm simply, for the sake of completeness, I think, trying to summarise what the effect of the new legislation is and how the legal landscape has changed quite dramatically since the 1970 Act, with which we are concerned, in its unamended form, was enacted.
Of course, that's unsurprising to English lawyers. You can't get people out of their homes without going to court in England.
Yes.
But what's more interesting is what the powers of the court are when you get there.
Yes. Well,
how much discretion do they have?
Well, the court has the discretion to suspend the creditor's right, and that brings me on to another point, I think, which arose in the discussion yesterday, because I think the question was raised whether in Scotland the prohibition on ejection without an order of the court was statutory or at common law, and I think reference was made to English provisions.
Yes.
Now, again, with some hesitancy, on a matter of English law, as I understand the position, statutory protection for tenants certainly was introduced or was given in England under the Protection from Eviction Act in 1964. and the Administration of Justice Act of 1970 gave the court power to suspend the creditor's entitlement to take possession of property where a mortgage or heritable security had been granted over it. Now, the equivalent Scottish statutory provisions to those provisions in the 1970 Act in England weren't introduced until the 2001 Mortgage Rights Scotland Act. And as I understand it, the prohibition on ejection, unless in very special circumstances, without an order of the court, at least until the 2001 Act, was entirely a matter of common law.
I think yesterday I was saying that the statute was a United Kingdom one, but I've looked at the Act, particularly the 1977 Act, which is the one currently in force, and that is, it does not extend to Scotland. But there is a good deal of common law making it clear, I think, that you can't proceed to eject people at your own hand, particularly in a case where there's a recorded title. It would really be unthinkable. So you have to get an order from the court in order to achieve that.
Indeed, my lord. And specific statutory protection was then introduced in the case of borrowers who have granted heritable security by the 2001 Act.
Thank you.
Which, as I think the Lady Hale perhaps is indicating, means that Scotland, I think, was about 31 years later than England in introducing that qualification to the creditor's right to enforce their security. If I may move on then to the second chapter of my submissions, which is a consideration of the terms of the standard securities. Your Lordships will see that, or have seen, that save for the identities of the parties and the security subjects, the securities are in identical terms, and we see one of them at pages 189 to 193 in the appendix in the core volume. This is a copy at page 189. Just reading from the beginning, we see that this is a copy of the standard security granted by Francis and Mrs. Annette Wilson. And we see the personal obligation or undertaking on demand to pay all sums of principal, interest and charges which are now and which may at any time hereafter become due to the bank by the obligant, whether solely or jointly with any other person, corporation, firm or other body, and whether as principal or surety. Now, as was anticipated by my Lord Roger yesterday, we do not found upon the terms of Declaration 2, which is to be found below that, which extends the personal liability of each of the grantors to liability for the debts of the other, even if not jointly and severally, because the bank has not sought in these proceedings to enforce any personal liability for her husband's partnership debt, which each wife has undertaken in terms of Declaration 2.
Yes.
In relation to both the husband and the wives, in each of these cases, the bank is seeking only to enforce the security which each has granted for inter alia the husband's debts. And my lord, my lady, that brings me in turn to my third chapter of my submissions.
Just before you leave the standard security, I noticed from Halliday's book, particularly the second edition, in a page which you haven't copied in the authorities, that it is fairly frequent in the case of securities granted in favour of a building society to have a provision in giving a right to eject a proprietor who is in occupation. That would be something which, according to this textbook, one would expect to find set out in the variation to the standard conditions. But I think I'm right. It looks fairly plain that that isn't contained in this particular standard security.
It's not. As my Lord Hope indicates, there is no equivalent provision in these standard securities. And as I understand it, it may be that some building societies do, perhaps in the advice of Professor Halliday, include that provision in their standard securities, but I don't understand that to be a universal provision in standard securities granted in favour of commercial lenders.
Right. Yes.
My Lord, then, my Lady, if I turn then to chapter 3 of my submissions, which I've labelled the default issue, my learned friend has in my submission quite properly conceded that the failure to pay on demand sums due to the bank would amount to a failure to comply with a requirement arising out of the security within the meaning of standard condition 9.1b.
9.1b,
B.
yes.
He got rather a lot of grief over that admission, did he not?
He might have, my lady.
Yeah.
I simply proceed on the basis of the concession, which I think was quite expressed.
You'd be open to the court to hold that the concession was wrongly made, though, wouldn't it?
It would be open to your lordships to do so, and if I can assist, perhaps at a later stage of my submissions on that issue, should your lordships or your ladyship wish me to do so, I'll be happy to do so.
Well, I think just looking at section 24.1, your point is perhaps put this way, that it recognises that you could proceed by way of a notice of default, but without prejudice to your actually doing that, where the debtor is in default within the meaning of standard condition 9.1b or c, you may apply. So your argument is, well, we can establish a default on the facts without having gone through the procedural step of a notice, and the mere fact that the fact that the sums sought have not been paid is sufficient for us to establish that that is the state of affairs, and you produced a certificate under 9.2 which shows that that is the state of affairs, is prima facie evidence that that is the position. So you set it up that way rather than by way of a notice. I think I followed that so far as it goes.
Yes, well, indeed, I mean, if I could adopt that explanation of the first part of my submission on that, and I think the only further point I'd seek to make is that I submit that the obligation to make payment under the security, just as the obligations to maintain the security subject in good repair, is a requirement arising under the security, and that failure to make payment on demand is a failure within the meaning of standard condition 9.1b.
Supposing that not this case, but supposing that you had a standard security backing up an obligation, a completely separate obligation, what then?
Then I would submit, my Lord, that would still be a failure.
Why would that be a failure to comply with the condition requirement arising out of the security?
Because I would say, my Lord, that what is security is being granted for the performance of obligations, albeit those obligations are constituted in a separate deed.
Well, could you point a bit in that event, what bit of the standard security would contain the obligation to pay any sum?
The standard security would have to be framed as indicating, as I understand it, that the proprietor is granting security for the performance of obligations by another person. Yes.
No, I'm thinking of a situation where I enter into some sort of agreement, and then you don't bother to take security, but subsequently you think, oh, well, you're a bit dodgy, so you ask me to grant standard security, and I use the form which then refers to the obligation under some other agreement. Now, in that situation, the obligation to pay is under the other agreement, isn't it?
Indeed, my Lord.
Not under standard security.
No personal obligation to pay is undertaken in the standard security.
No personal obligations.
Yes.
No. So how does it How would it, I was just asking, how would 91B
Yeah.
work in that situation?
Well, I suggest, my Lord, that it works because the grantor of the security is granting security for the obligations undertaken by the borrower separately, and that the failure in any of the obligations which are secured is a failure to meet a requirement arising under the standard security.
How does one compare that with 91A in section 20 and the calling up notice? Because if one was driven to say, contrary to what you just submitted, that because it's the personal obligation is not to be found within the security document itself, it's to be found in a separate deed. And that means you can't proceed under 91B. You would have to go under 91A, and you would have to call it up. How would that work? Would that personal obligation fall within the opening words of section 19.1 as a debt secured by the standard security?
Yeah.
And that's good enough to
Absolutely.
to catch that situation, isn't it?
Yes, my Lord. Yeah.
Thereby secured. And there's nothing in standard condition 91A that gives rise to any difficulty there.
No, Section 19, Section 19 is framed on the basis that the person who has granted the security, that is the proprietor, may well not be the person who has incurred the debt or obligation which is secured. Because your Lordships and your Ladyship will see that in terms of subsection 2, the obligation is to serve a notice of calling up on the proprietor. And the only reference to a debtor is in subsection 5, where it's indicated that should the creditor wish to preserve a right of recourse against the debtor, if not the proprietor, a copy of the notice requires to be served on the debtor.
I mean, I'm just sort of, I fully, if I may say so, accept that. But I'm just interested in the one where
Yes.
the obligation is outside the deed.
Yes.
Then in that situation, it seems to me perfectly plain. You could certainly use section 19 to call it up. If there's any question about that.
Yes.
The question is whether, in that situation, you could use the alternative notice of default. Now, if you can't, it's slightly odd that you can use the notice of default in one situation and not in the other. You may be right. I mean, it's just maybe an anomaly of the way it's drafted.
It may well be. It wouldn't be the only anomaly, as I think your Lordships and your Ladyship have noticed thus far. But if my submission is not well founded, then I quite accept that, as your Lordships are indicating, there would be an alternative route open to the creditor in that situation. But of course, we are dealing with a situation where, in these standard securities, the obligation secured is being constituted in the same standard security.
In Schedule 2 to this Act, Form A and Form B are alternatives depending on whether the personal obligation is in the standard security or not in it. But when I asked you yesterday about interest, and that there was nothing about the dates and intervals at which interest should be paid, you said, oh, well, in these cases, there'll be a separate loan agreement. But that's not pleaded. The matter comes before us as if it was all in the standard security, doesn't it?
I may have misunderstood my Lord Walker's point then yesterday. I had thought I was agreeing that although the standard security provides that any sums will be repayable on demand, it's quite possible that separate loan agreements might have contained a different provision on the date of payment. Or
well, I know. I was asking specifically about interest,
yes.
Because if the debtor looks at the document at page 189 to find out how much interest he has to pay on what dates,
yes.
He gets no answer at all. And it was in response to that I understood you to say, oh, well, that'd be a separate loan agreement.
Well, yes, I wasn't seeking to found upon the separate loan agreements. I had only intended to agree with my lord that although the standard security makes an express provision that the bank may determine interest in the absence of agreement, or that there may well have been separate agreements, loan agreements which had other provisions, but I wasn't seeking to found upon those other agreements in any way for the purposes of my submissions.
Well, if the standard security doesn't, I'm sorry, it's a fairly obvious point, I won't keep on about it. If it says nothing at all about the intervals at which interest is to be paid, it's quite hard for the bank to come along and say that the debtor is not paying interest promptly, because there's no obligation.
Yes, I don't submit, my lord, that the bank is entitled to found upon the failure to pay interest punctually. The confusion may have arisen as a result of the submissions I made in relation to the proper interpretation of Section 5 of the 1894 Act. The only point I sought to make there was that it is not always necessary under Section 5 of the 1894 Act for a formal requisition to have been served, because I submit that that section would also entitle a creditor to eject if there has been a failure punctually to pay interest, and without any formal requirement to requisition for that interest to have been served. But the fault is obviously mine in not making it clear enough that I don't found upon a failure to pay interest as being a ground on which the bank, in these cases, would be entitled directly under Section 5 of the 1894 Act to eject the borrowers.
Does that mean if Section 5 has to be invoked in this case, it would have to be on the basis that there's been a failure to make due payment of the principal, which would mean there would have to be a formal requisition?
Well, my lord, my submission would be slightly different, but I am almost at the point where, in terms of the chapters of my submissions, I'll be addressing that issue directly, and I wonder if I might...
All right, I think I know where you're going here.
Yeah. As I understand it, the point taken against me, if I'm correct in my submissions as to there being, as to a failure to pay the sums due on demand being a failure to comply with a requirement arising under the security, the point taken against me by my learned friend is that the bank's letter or letters requiring payment did not amount to a demand.
So you're coming back to 19 at some point, are you not?
To Section 19.
Section 19.
Yes, I'll be coming back,
All right,
my lord, on the ejection issue, which is the next chapter.
Okay, yes.
Yeah. But simply dealing with the default issue, as I understand it, the point taken against me here is that the bank's letters to the husbands requiring payment did not amount to a demand, as payment was being required under the personal bonds in the standard securities, and in those circumstances, a valid demand required the bank to make clear that failure to pay would or might result in the enforcement of the securities.
I think the argument was directed to the concluding words of Section 5, and that letter couldn't be, it was said, a requisition, partly because of the terms in which it was expressed, but also because it wasn't actually served on both proprietors.
Yes, I understood there to be submissions that the letters would not amount to a requisition, a formal requisition in terms of Section 5.
And you would accept that, would you?
Well, I don't... In my submission, it might be arguable that the letters do amount to a formal requisition, but that is not an issue on which I'm inviting your lordships to rule, because I accept that those letters were not sent to the wives.
Right.
And therefore, it aids me to no extent, even if the letters sent to the husbands were requisitions, because a decree to eject one pro-individual proprietor would be entirely unenforceable, even if competent.
So at least on one of the two grounds, you have to accept that it wouldn't satisfy the formula at the end of Section 5.
Yes, Yes. Hold on.
What is the purpose of these letters on your approach?
The purpose of these letters is to demand payment of the debts which are due and thereby render the obligants liable to make payment.
In other words, put them into default.
Put them into default. My Lord.
Is that right?
That would be one of the consequences if my Lord Roger is using the word default in the sense of the 1970 Act.
Yes.
Yes.
I mean, what other purpose does this letter serve?
Well, if we look at the letters, my Lord, I think we'll see what the bank is doing is saying we are now requiring you to make payment. We are still, in fact, prepared to try to negotiate some agreement with you for the repayment of these debts, but
Well, that's
you are
all
now.
very nice, but I mean, supposing that, I mean, as I understand it, you had to send them a letter. You had to do something. You had to demand payment. Because only if you demanded payment, am I right, that they would be in default. Is that correct?
Yes, my Lord.
Yes?
Yes.
Is that right? Or am I wrong?
I'm accepting that, my Lord. And I'm simply going to add that a demand would also be necessary to trigger any personal liability on the part of the wives in these cases for the husband's debt. Because the obligation undertaken in the personal bond by the wives again is to make payment on demand. But I quite accept that the consequence of these letters would be to put the husbands in default within the meaning of Standard Condition 9(1)B or for the purposes of the 1970 Act.
Well, how does that measure up to Schedule 6, Form B? Because we have a form which is referred to in Section 21, I think, which tells you what form you use if you want to have a notice of default. And one of the things that strikes one is that it does actually say that failing fulfilment, the powers competent on default may be exercised, and it's notice that this is something that's served not with reference only to the personal obligation, but also with reference to the position of the recipient of the letter under the standard security. Yeah. I'm not sure that I can find anything in the letter that actually does that.
No, I don't. I don't submit that the letter would amount to a notice of default within the meaning of Section 21 of the Act and in accordance with Form B.
Right.
But as my Lord Hope has noticed, of course, the remedies under Section 24 are without prejudice to...
That's your whole point, isn't it? Section 24 gets you home and dry without any of this.
Well, indeed.
That's your... I mean, that's why I'm saying all you need to do is to make a demand which puts the person into default. Then you have a possibility of going... You could then have a notice of default, but you say, well, I'm not going through all that rigmarole. I just go to 24. Is that right?
That is, my Lord. That is my submission.
But then you need Section 5, do you?
Indirectly, my Lord, and that is the next chapter of my submission. If the point being taken against me then is not that these letters fail to meet the requirements for a demand in terms of the standard security, if that is no longer an issue, then I can move now directly to...
I mean, I'm just putting the way I see it. I mean, they may be wrong.
No, I had understood my learned friend to be arguing first that the letters sent by the bank did not amount to formal requisitions in terms of Section 5 of the 1894 Act.
Yeah.
And I say, I'm prepared to concede, I'm not inviting your lordships to decide that, because I cannot say that these letters went to the wives who were the co-proprietors. I had understood, but perhaps wrongly, it was also being suggested that these letters did not amount to a demand for payment for the purposes of the personal bond. That is to say, they didn't meet the requirements of a demand for payment in terms of the personal bond.
Of the husband's personal bond?
Yes, the husband's personal bond. Yeah. Now, if I've misunderstood...
No, I may have misunderstood.
No, that point seems fairly straightforward as far as it goes. The point that was troubling me is that there's nothing in the letter that refers at all to the security deed,
Yeah.
leaving aside that the letter wasn't sent to the wife as well.
Yeah.
But your position is that all this is irrelevant, really, because the opening words say without prejudice to proceeding by way of a notice of default. You can go straight to the court. And what you're asking the court for is a warrant to do certain things, which you don't have to ask for a warrant under the calling up procedure.
No.
That isn't actually in the formula which the earlier sections use, but section 24 does use it.
Yes.
But that then begs the question: what are the remedies which section 24 is talking about,
Yes.
and whether ejection is one of them?
Yes. Well, my Lord brings me to...
Just before we go past that, just so I'm clear, I mean, if you say that this letter is good enough as a demand, then it has to be a demand in relation to a requirement arising out of the security.
Yes.
And you say, you say is, do I understand it, that the requirement to pay arises out of the security in this case, because its personal obligation is included within the security. Is that right?
Well, yes, I say that...
Is that
I say
right?
the obligation to make payment is equivalent to any of the other obligations imposed by Schedule 3 or by contract otherwise, and is an obligation arising under the standard security.
And therefore, you say that in fact you demand that, even though you don't refer to the standard security, that's all right. Is that right?
Yes.
Whereas I think Mr. Summers says, well, that's not enough, because if you're referring to the obligation under the security as opposed to just the obligation to pay, then you should mention it.
Yes, but I say the obligation undertaken in the standard security is to repay these debts on demand. The only condition...
Yes, he's saying the demand is not clear enough,
Yes.
because to turn it into something arising under the security, because you don't make that clear in the demand.
Yes,
That was his third submission.
yes, but I say the focus is on the obligation arising under the security, not on the notice. If the obligation arising under the security is one to make payment on demand, failure to make payment after demand is a default. And that this is not a case where the bank is seeking to rely on a notice of default under Section 21 or a notice of calling up under Section 19.
But it was seeking to rely, without more, on the fact that it had demanded payment from the husbands
Yes,
as giving it a right to enforce its security,
indeed, my lady.
without
because-
having made it clear that that's what they wanted to do. It's not a lot to ask, is it?
Well,
It's a big bank. It's got people who can press buttons on computers.
And you've got a nice form set out in Schedule 6, which gives you some idea of the kind of information that you should provide if you're wanting to use Section 24.
well, I can't inform your lordships on the banks and your ladyship on the bank's policy at that time as to what information it considered necessary to provide or not. Clearly, since 2001, the position has been very different.
Well, I wonder whether you could explore for us what is meant by remedies. What are the remedies that are referred to in Section 24.1? And can I just explain why I'm asking this question? Because in the passages in Halliday's second edition, which you haven't copied in the bundle, and I'm afraid I have to just tell you what he's saying, he says, well, there are certain remedies which are referred to expressly in the standard conditions, standard condition 10, and you can see them listed in standard condition 10, but one of it is quite easy to see that ejection is not mentioned there. Then there's another group which he says you can find in the standard condition, in the standard security itself, because it is open to the parties to vary the standard conditions, and I already mentioned his point that the building societies usually put in a provision to the effect that they have power to eject. Now, if it was in the standard security, that would be brought in by the phrase, says Professor Halliday. But you don't have either of these. You don't have the benefit of a provision in the standard condition 10. You don't have the benefit of a provision in your own standard security. So that suggests that you're asking for a remedy which you have to obtain independently under, I think, Section 32, which tells you that all the various statutes which preceded the 1970 Act apply. So Section 5 is available, but the implication, I don't think he actually says it in terms, but the implication of the Halliday approach is if you're going to have to go to Section 5, you have to meet the requirements of Section 5. So you have to have a requisition. That's, as I see it, the sense of his approach. Now, I wonder what your answer would be to that.
Well, my answer would be, my lord, then I move on to this further chapter, the ejection chapter. My answer would be the analysis must begin with a consideration of the remedies open to the creditor who has served a notice of calling up under section 19.
Yes.
And we see in section 20, which is on page 16 of tab 2, subsection 1. That where the debtor in a standard security is in default within the meaning of standard condition 9.1a, that is the service of a notice of calling up, the creditor may exercise such of his rights under the security as he may consider appropriate, and any such right shall be in addition to and not in derogation from any other remedy arising from the contract to which the security relates. And that's one of the points I think my Lord Hope was indicating that Professor Halliday, I think, makes then in his textbook on conveyancing. The contract to which the security relates, or from any right conferred by any enactment or by any rule of law on the creditor in a heritable security. And the next stage of the analysis, again, is one I think Lord Hope really has anticipated, that section 32 of the Act has the effect of allowing the creditor who has served a notice of calling up to proceed to ejection by virtue of the terms of section 5 of the 1894 Act.
Yes.
So that is one of the remedies open to the calling up creditor.
Under standard condition 9.1a.
Under standard condition 9.1a, by virtue of the interplay of sections 20 and 32 of this Act and section 5 of the 1894 Act.
Yes.
If you've complied with section 5.
Indeed, as this, the standard condition 9.1a creditor has by serving a notice of calling up. So that is the position of the creditor who has served a notice of calling up. The next stage of my analysis is to submit to your lordships that if we look to the substantive remedies conferred by standard condition 10, that is the power of sale, the right to enter into possession, and so forth, the legislative intent clearly is to put a section 24 creditor into exactly the same position in relation to those remedies as the creditor who has served a notice of calling up.
So, could I have that again?
Yes, I say the legislative intent is to put the creditor who obtains warrant under section 24 in exactly the same position as the creditor who has served a notice of calling up, insofar as the substantive remedies conferred by standard condition 10 are concerned.
Is it right to contrast the wording of section 24(1) with the wording of section 20(1)? Because not all the words that we find in section 20, subsection 1, appear again in section 24(1).
Yes.
I think I'm right in saying that there is common ground in this respect, that section 20, subsection 1, begins by saying that the creditor may exercise such of his rights under security as he may consider appropriate, and that would no doubt embrace standard condition 10. And then it goes on to deal with other things, whereas what section 24 is talking about is a warrant to exercise any of the remedies which he is entitled to exercise on a default within the meaning of standard condition 9.1a. So how do we get beyond the standard conditions in the formula used in section 24?
Because as I read those words, my lord, what is being said there is that the creditor obtaining warrant under section 24(1) or applying for warrant under section 24(1) may apply for warrant to exercise any of the remedies which he is entitled to exercise on a default within the meaning of Standard Condition 9.1a.
Yes.
So Standard Condition 9.1a is being used there to define the nature of the default.
You say that takes you straight back to section 20, subsection 1.
Indeed, precisely. That is my...
It's just a shorthand for saying
It is.
the remedies that are set out in section
Yes.
20, subsection 1.
Yes, I say there's an intermediate stage which is to consider that in relation to the substantive remedies, the Act has already put both these creditors in the same position.
Yeah.
I say that goes further, it extends to the ancillary remedies which might be required to make the substantive remedies effective.
What you say is that by, if I've got you right, is that by doing that, with one bound, you are free of the requirement in section 5 to serve a formal requisition.
My lady, yes.
Because you are put into the position of somebody who has served a calling up notice,
Exactly.
that frees you from the requirement in section 5. That's what you're saying.
But that is precisely what I was struggling to...
It's a bound.
You weren't struggling.
Well, I follow that so far as it goes, but it's a bound which gets you back to section 20, subsection 1. But then section 20, subsection 1 is written against the background of the calling up notice under section 19.
Yes.
And the final bit about rights conferred by any enactment on a creditor in a heritable security allows the section 20, subsection 1 person to apply under section 5, but he's got the benefit of the calling up notice.
Yeah.
But the real question is whether, if you make this wonderful leap, which Lady Hale has described, whether you've leapt over that requirement as well and got right over the top of the fence to enable you to proceed without actually having any kind of notice served on the proprietor indicating you're going to enforce the security right at all.
Well, I simply say, my lord, that not having followed the notice routes under section 19 or 21, but gone instead to apply to the court for warrants.
Yes.
What section 24.1 is doing is saying that creditor is to be placed in precisely the same position as he would have been had he constituted a standard condition 9.1a default.
Doesn't say that.
It doesn't say that in precisely those terms, my lady.
It doesn't say that. It
No.
says you have the same remedies.
Yes.
Those remedies we have worked out by reference to section 32
Yes.
include section 5, but section 5 has its own internal requirements.
Yes, but
Now, as I understand it, it's common ground that the calling up notice, if it's going to be valid as a calling up notice, will also be valid as a formal requirement. But that doesn't tell you that you who have served no such notice are exempt from the requirement to serve a formal requisition. It doesn't tell you that, does it?
it doesn't say so in express terms, but I say that is the consequence of what I say the proper construction of section 24.1 is, which is that one is placed in the position of a creditor who has done that. Because in one sense it would make little sense for section 24.1 to say you are entitled to exercise the remedies of a section 19 calling up creditor, but you still have to go through the section 19 process, because one could have done that anyway, or can do that anyway.
That's not the point, is it? Forgive me, sorry, I didn't mean to cut you off. The point, the section 19 process is somewhat more elaborate than possibly the formal requisition process, because it's got time limits built into it and a statutory form. And I think it's accepted that there might be other ways in which you could give the required information and it wouldn't have the time limits built into it. So it's not being suggested that you have to go through the section 19 process, it's being suggested that you have to do something that complies with section 5. Am I right? I think that's what the suggestion is. And that they're not identical. The calling up notice would comply with section 5. That doesn't mean to say that you have to go through the whole of section 19.
Well, I take my lady's point that it may not be necessary to...
I mean, I'm sure that must be right, but what I was going to suggest is that when you look back at section 20, subsection 1, and you look at the reference to rights conferred on creditors and a heritable security, it does beg the question as to whether you actually can rely on Section 5, given that a formal requisition is required. And the answer to that is, well, yes, certainly, because it's preceded by calling up notice under Section 19, which goes a lot further than you might think was needed, but at least it meets the basic requirements. Yeah. But then you come back to Section 24, and you've proceeded without a notice of default. And the question is, well, can you really successfully argue that you're in the same position as somebody who served a calling up notice without having done anything like that at all?
Well, I say so. I say one can, just as, without serving a notice of calling up, Section 24 can put the creditor in precisely the same position in relation to the substantive remedies.
This is where we come back to really the basic point as to whether or not it is legitimate to use the 9(1)B route in a situation where, in effect, what you're doing is calling up the standard security. You're actually calling up, you're doing what is 19. That's what you're really doing. So when you say come back and you say, well, why in heaven's name should I then have to do it? Should I then have to serve as a formal requisition? Because that would put me, I might as well have, it wouldn't give me any advantage because I might as well have had a calling up notice. Well, the answer may be, of course, well, that just shows you should have had a calling up notice.
Or the answer may be that the Act quite deliberately provides these alternatives and that they are used in different situations, as we were discussing yesterday.
One can test Lord Roger's point by looking at some of the things referred to in standard condition 10, because one of them is effecting repairs. Standard condition 10.6, and you wouldn't really, I would have thought you wouldn't need to call up the standard security to do that. You would ask for a warrant to allow you to actually go ahead and do these, effect repairs and effect reconstructions and so on, so that you can maintain the security subjects in a way that the debtor is not doing. Yeah. And that's a right which you get from the court to exercise a remedy which is to your advantage as the creditor in the security. But the security remains. You haven't bothered about calling up the debt because no doubt the interest is still being paid or whatever. You're worried about the principal, but you're not asking for payment yet. But you want the value of the secured subjects to be maintained.
That would be one option, my lord, yes, but it's at the creditor's option, because the creditor, in that event, a failure to maintain the property in good and proper repair, could serve a notice of default under Section 21, and if that notice is not complied with, Section 23, subsection 2, confers on the creditor the remedies of the power of sale, the power to effect repairs at his or her own hand, or to apply for a decree of foreclosure. And if, as a result of the failure to repair, the creditor chose, instead of serving a notice of default, to apply to the court for warrant under Section 24, the right to enter into possession would be conferred upon the creditor as a result of that defect in the repair of the building. But the Act, in its, I say, strictly, rigorously contractual form, gives the creditor all these options.
Right, I'm sorry to mention, because you obviously know so much more about this. What strikes me is, why is it, can I just ask this, why is it that when you serve a calling up notice, that's what it's called, there's no specific thing which deals with, the chap says, well, I paid. There's nothing in it which says he can apply to the court, whereas when a notice of default, it says, if you're disputing it, then you can go to the court and make an application, and then the sheriff looks at it and says, yes, you've done it, or whatever it is. Why is there no mechanism for that? Am I wrong?
No, I can't find a mechanism myself, my lord.
Why is that? Now, what does that point to anything?
I think if it points to anything, that presumably Parliament thought the debtor in those circumstances could challenge the calling up notice by way of reduction, perhaps, or suspension,
Interdict or something.
or interdict.
Yeah, I can see the ways of doing it. It's just slightly odd that there's no mechanism for serving a counter notice or whatever it is, whereas you get it for the notice of default. And sorry, I beg.
I'm sorry, I'm afraid we're unable to assist your lordships in that.
Well, what I don't quite understand is why these two, little a and little b in condition 9, are mutually exclusive. And section 19 makes that quite clear, because in a section 9(1)a case, where a creditor intends to require discharge of the debt thereby secured, and failing that discharge, to exercise any power conferred by the security to sell, or any other power which he may appropriately exercise in default, he shall serve a notice. That's an obligation imposed by section 19. And those are the very things that your clients seek to do. You were under an obligation, your clients were under an obligation, weren't they, to serve a calling up notice? They didn't. And in those circumstances, it's quite inconceivable that the statute intended that they could duck that by doing something completely different. That may be too simplistic a view, but so seems to me to have a certain ring to it.
Well, I urge your lordships and your ladyship to reach a different...
But why is that wrong?
First, we looked yesterday, I think, at the case of Millward.
Never mind about the case. Just tell me as a matter of analysis why it's wrong. I suggest to you that that decision is wrong, and the reason it's wrong is for the reason I've just given.
Yeah. Because I submit that on a consideration of the whole scheme of the Act, insofar as one can attempt to analyse it in a coherent way.
But it's right that your clients are in breach of the obligation under section 19, aren't they? Or have failed to comply with it.
Well, if it is read as being a mandatory...
Well, it says shall.
Yes.
What else is it?
Could be scarcely more mandatory than shall, could it? I suppose must.
Well, of course, the word shall would normally import a mandatory obligation, but it needn't necessarily.
Well, what do you mean? What do you mean it don't need necessarily? I mean, of course, you have things shall do this, that, and that thing, and it may not mean that the next step isn't possible, but it doesn't mean you shall never means may. I mean, the division said it may.
Yes.
I mean, but when Parliament says you shall do this, it doesn't say, it's not saying you may do it, is it? I mean, there are obligations which say you shall do something, and if time isn't of the essence, well, it doesn't matter if you haven't done it by a particular time and so on, and then you can still proceed in a different way. But it doesn't mean you may do it.
So then when we get to section 9, or the paragraph 9 of Schedule 3, the debtor shall be held to be in default in any of the following circumstances, that is to say, A, where a calling up notice in respect of a security has been served, and we know when it must be served, see section 19, B, where there has been a failure to comply with any other requirement. So you only get to B in a case that isn't within A. We know this is within A because of the obligation in section 19. And that's a simple answer to all these problems, and all this interesting sophistry doesn't come into it. And what's wrong with that?
I suggest, in my respectful submission, that looking at the terms of Part 2 of the Act and the standard conditions as a whole, it is, in fact, reasonably clear that Parliament has chosen to confer on the creditor the options of pursuing these different...
Well, why does it say shall in section 19?
If one is looking just to try and get a coherent scheme, and really just echoing what my Lord has said, that you get standard condition 9, 3 different cases: failure to comply with monetary obligations, failure to comply with other, and you did rather pass over the word other requirement in B, and then insolvency in C, which again is a different case, which has different consequences. That's a much, much simpler scheme than what you're trying to persuade us is right.
Well, I would say, my Lord, that In my submission, it wouldn't be accurate, at least to define those three categories so as to exclude from the second any monetary obligation, that is to say, a notice of default. I mean, in a typical building society security, the borrower will be under an obligation to pay interest normally monthly or perhaps annually. If there is a failure to pay interest when due, in my submission, it would be perfectly open to the creditor in those circumstances to serve a notice of default and thereby create a standard condition 9.1b default if the failure is simply to pay 1 or 2 or 3 months interest and the creditor is satisfied that if that interest is paid, no further action would be
When did you ever hear of a building society taking proceedings, saying you're behind with your interest, pay the interest, but we're not going to call in the mortgage? It doesn't happen.
I quite accept that in reality, I'm sure my Lord Walker is quite right. I'm simply indicating that in my submission, that would be an option open in relation to a monetary obligation under either Section 21 or by means of a Section 24 application to the court, if there is arrears of interest.
Mr. McCormack, could we just go back to 19, just looking at 19.1, because this was a question I was going to ask him. And it does depend a bit, doesn't it, or what is meant by requiring discharge of the debt.
Yes.
As I understand what the inner house held, in the extra division held in Millward, they said that that applied only to the discharge of the entire debt.
Yes. So
that Section 19.1, supposing you owed me 100,000, and I wanted you, and there was no time thing on it, and so on demand, and I said, well, I'd like to have 50,000, thank you, nothing about interest in it, so I just like 50,000. And you said, well, I can't pay 50,000. Well, I say, well, I'm going to have 50,000 from you, and if not, I'm going to excise power of sale or any other things. Now, that seems to me to be requiring you to discharge, not the whole of the debt, but part of the debt. And I can't for the life of me see why, if it is required to go through 19.1 and the calling up notice and so on, give you all this notice, if you're going to have to do that for 100% of the debt, in a way what I'm doing is more draconian. If I'm only doing it for 50% of the debt, why shouldn't I be required to make the same there? In other words, why should we read discharge of the debt as referring only to discharge of the entire debt? In other words, why?
Well, because in my submission, that would be the plain meaning of the words discharge, first of all, of the debt.
Well, that depends on what's meant by debt, which is defined in Section 9, 8c, which says debt means any obligation due, which would include the obligation to pay one instalment of interest.
Yes. But
So that won't do, really, would it?
so my submission is that one wouldn't normally talk of discharging a debt unless one were repaying the debt in full.
But there's a new cause of action accrues every time an interest payment is due. It's a separate cause of action, like a payment of hire under a time charter, like many instalment provisions. And each one is a separate debt within the meaning of the definition, and thus within, surely, Section 19.
And you can adapt Form A in Schedule 6 to meet that situation, I think. You just fill in the sum you're asking for. And Form A is designed for calling up monetary obligations. It can be adapted if the security is in favour of a non-monetary obligation, but it's all designed with reference to the obligation for which the security is given, whereas Form B really looks as though it's really dealing with the obligations which are there to preserve the security.
Well, in my submission, it's slightly more open than that, because Form B could quite easily be adapted to say that the matter which requires to be remedied is the non-payment of interest, for example, for 1, 2 or more months. And certainly in practice, as the division indicated in Millward, that is what that form is very often used for. Mm-hmm. But it would be open, given the wording of Form B and the terms of Section 21 in my submission, to a creditor to require payment of part of a debt by means of a notice of default.
But is your position that unless I require payment of 100% of the debt, I can never use the calling up? I cannot use it, and I'm under no obligation to do so.
Well, I say that insofar as it might be prescriptive, that it is only in circumstances where the whole debt is to be discharged, where that is the requirement.
Can I use it? Can I use it?
Well, one could certainly use it for part of a debt.
I could.
Because if nothing else, the failure to make payment in response to that formal demand would, I say, give rise at least to default within the meaning of standard condition 9(1)(b). It would be a failure to...
Oh, well, that's a different point.
Yes.
Why can't you use section 19 in a situation where, for example, the principal sum is to be repaid by instalments? Let's leave the interest complication out of account, but it's not unusual to say, well, 10% of the principal sum shall be repaid on a given date. And if there's a failure to meet that date, then there is a failure to fulfill a personal obligation. And why shouldn't that be the subject of a section 19(1) calling up notice using Form A directed to that particular instalment?
But, well, I say, I mean, it's open to the creditor to use the form for that purpose, but if nothing else, that will result at least in a standard condition 9(1)(b) default. But I submit that it's also open to the creditor in those circumstances to serve a notice of default under section 21. And I say it's also open to the creditor in those circumstances to apply directly to the court under section 24 for a warrant to exercise remedies.
But you say you cannot serve a calling up notice to bring you within 9(1)(a) unless it's the entire debt. That's what you're saying, is it?
That is my submission.
So it's in Lord Hope's example, for example.
That's right. I think that's
Is
what
that
you
your
are saying.
I think ultimately I nail my colours to Millward and say that is the position.
So
Yes, but you haven't explained why Millward is right.
Poor Mr. McCormack.
And I used to do cases before Mr. Justice Brandon, and he always said the first thing you should ask about any case is it rightly decided?
I can't add to my submission that on a consideration of the whole scheme of Part 2 of the Act and the standard conditions, the proper interpretation of Section 19 is that it confers an option on the creditor and does not oblige him or her.
Well, in this case, you are requiring, your notice requires the payment of what you say is the whole of the debt. So on the face of it, in this case, your letter, dated the 20th of June 1995, satisfies the first few lines of Section 19, subsection 1. It follows, therefore, that the bank shall serve a notice calling up the security. It didn't.
Yeah.
That's right.
Well, I can say as a preliminary matter, of course, that in at least one of these cases there was another debt, that is the mortgage, which wasn't called up. But I take my Lady Hale's point that debt in Section 19, I think, must be taken to refer to any of the particular debts which are secured by the standard security.
But just looking at the letter at 195, rightly or wrongly, the bank seems to have thought it was calling up the whole of the debt.
Yes.
It was certainly insisting on payment of the whole of the debt. I think we see that the two major debts are debts in a business current account, so I think one can assume that those are overdrafts repayable on demand. So the liability to make any payment would be conditional on the bank having made...
Yes, there are two business current accounts and indebtedness on a business term loan are the three items in page 194.
Yes.
I think in fairness to you, Mr. McElready, if I might just draw attention to the way the division in this case, the extra division, quoted from Millward, because one could see that what was being said in Millward was simply a narrative of practice. Now, the practice may be wrong, but so far as it goes, what Lord Maclean was saying is that it seems obvious to us that conveyancing practitioners use notices of default, even in situations where they could, he said, use calling up notices. He doesn't use the word should, which perhaps he should have done, but he says could, and he bases that on what Professor Halliday says, where he slides around the word shall and uses the word may. I mean, it's really, it goes back to Halliday's book, which I think was published in 1970, shortly after the Act came into force. And practitioners seem to be doing what the professor suggested, rather than tying themselves to the language of the statute.
Yes, I mean, I quite accept that it wouldn't necessarily be an aid to construction of the statute. What practice has grown up on the basis of Professor Halliday's advice. But I think, as I've attempted to submit earlier, I think on a fair reading, the division in Millward is saying that that is the case and clearly was a factor that had some bearing on the decision they reached, but that really the rationale for the decision they reached was that one has to look at the full scheme as set out by Part 2 of the Act and the standard conditions, and that on that basis...
Right, Mr. McCormack, where did you find that in their decision? I thought it was all to do with saying that this shall was permissive.
Yes.
I mean, if I had found a great analysis of that, how it all fitted together, I would have been quite impressed, but I didn't think I saw that very much.
It's at tab 10 of the first volume of the Authorities, my lords, my lady.
Tab 10, thank you.
It's really on page 903, isn't it?
On page 903.
It is, yes. And it's at letter E where we see the word may being used instead of shall.
Yes.
In the end of the submission for the pursuer, whatever it was accepted the pursuer's submission was correct. The word shall, section 19, had to be read in a permissive and not a mandatory sense.
Yes.
The part where I take the point I was putting to your lordships and your ladyship, I think, is on page 903 between letters G and H, where there's... his lordship begins by referring to a conveyancing practice.
Yes.
But just 3 or 4 lines...
But we're construing the statute.
Yes.
Yes.
I mean, conveyancing practice is little to the point. The question is, what does the statute mean?
Yes.
Now, the first difficulty with the pursuer's argument is that it depends upon section 19 referring to the whole debt, and that appears to be wrong. Then it's accepted that it involves reading shall as if it said may, without any reasoning, except conveyancing practice. Well, conveyancing practice is no help, surely, in construing the words of the statute.
But I entirely take my Lord Clerk's point, but if I could just direct your lordships and your ladyship to a passage or sentence meaning about 3 lines above the letter H on page 903. We see that having referred to conveyancing practice, his lordship goes on to say, we do not think that the statutory framework in sections 19 to 22 of the Act necessarily leads to such a conclusion, and then goes on to say, in our opinion, the law is correctly stated.
That's very informative.
Yes,
very
but
informative.
well, I take from that, my lords and my lady, that the division had considered the scheme of...
Yeah, but why is that?
Kept it secret from us.
They don't explain why they say that.
Yeah. Well, I hesitate to try to provide the division's reasoning, but my reasoning on that would be that, as we've seen from our close analysis of the sections 19 through to 24 and Schedule 3, the whole purpose of that part of the Act is effectively to confer a number of options on the creditor.
Well, except for shall.
And the point is really, I mean, this case, it just demonstrates the difficulty with that argument, because you're trying to obtain the benefit of the security and obtain ejection without giving the kind of notice which Section 19 contemplates. Now, it wouldn't matter so much if you were using an alternative route which achieved the same result by some other process. I mean, so long as the formalities were fulfilled in some way, then you might say, well, they are really so comparable with each other that you can treat them as options. But where one option is so clearly deficient in what one would normally think was a fair and necessary step to take, it seems very difficult to accept that they are truly options.
Yeah. But then your lordships and your ladyship, in my submission, would nevertheless have to accept that without giving prior notice, Section 24 at least enables a creditor to apply for a warrant to sell the borrower's house. Without giving prior notice, Section 24 allows...
But that might not be to sell it with vacant possession.
No, there may be practical difficulties for the creditor in doing so, but in substance, it may be hard to see the difference so far as the borrower is concerned between being immediately ejected or having their home sold over their head and thereafter being removed by the new proprietor. But in any event, I say Section 24 allows the creditor without prior notice to obtain the power of sale.
But only a case within condition 9(1)(b.
Yes.
And on this analysis, on the analysis suggested to you, you don't get to 9(1)(b) if it's a 9(1)(a) case. So Section 24 has no application.
Well, my point...
Section 24 only gives the remedies, the 9(1)(a) remedies, in a 9(1)(b) case. If it isn't a 9(1)(b) case, then Section 24 doesn't apply.
Because the creditor has already, in a 9(1)(a) case, already has those remedies and the additional remedies, the ancillary remedies by which they can be made.
But he has remedies as long as he just complies with the obligations of the statute to serve up the notice, and then he serve the notice, and the statutory notice expressly provides for notice to the proprietor.
Yeah. But I'm simply attempting at this stage, my Lord, to address the point that there may be some unfairness in the borrower facing ejection without there having been a prior notice, and I say I leave the question of unfairness aside. What is clear from the Act is that the borrower without prior notice, I say, can quite plainly be facing a creditor with the power of sale and the power to enter into possession.
I suppose, I mean, the protection for the borrower, part of the protection presumably is that the sheriff isn't there just to rubber stamp any application which is made, because they have to apply for warrant. Isn't that right?
Yes.
To exercise these powers. And the sheriff could say, well, no, that's not going to grant you it, couldn't it?
Well, the sheriff would now have that, certainly would now have that power.
Under the Act, as it is.
That's what Section 24 is telling you, that a warrant is needed to exercise these, which you don't require to have a warrant under Section 20 if you proceed that way, but you do under 24.
Yes. The warrant is required, yes. The warrant from the court is required. I quite accept that, my Lord.
But you don't necessarily accept that the court's got any choice in it.
Well, I wouldn't like to mislead the court, as I understood it. I mean, there is authority. Previously, it's not in the bundles, I'm afraid, but that the court, under the 1970 Act as originally enacted, did not have a discretion to refuse. Yes.
Well, what's the point of the person having to go to the creditor having to go to the court to apply for a warrant?
Yes. Well, it does seem to make it rather strange that one should then be required to go to the court if it's simply a rubber stamping exercise.
Well, no discretion at all. I mean, suppose the proprietor has no notice of any kind, whatever, but can show beyond a peradventure that there's no liability.
Well, no,
there's no discretion then. It's only. I feel sure the decision must say that once it's established that there is a liability, then there may be no discretion. I can see that.
Yes. No, that is,
these days that wouldn't work, but I can see in the old days it might have been thought to be right.
No, my Lord, that makes the next point I was going to say, that the only point I was trying to address was the question of whether the court, ex proprio motu, at his own hand, had a discretion. But clearly, the debtor is entitled to enter the proceedings, and this is the point we were discussing yesterday.
It was a problem that arose in England a long time ago, in the mid-1960s, because judges began to assume that they had quite a wide discretion to postpone the operation of an order for possession in actions by mortgagees. And then the Court of Appeal decided this was wrong, and that they only had a discretion to give just what common humanity required, a couple of weeks. And it was that led to the provisions of the Administration of Justice Act 1970, which you mentioned earlier this morning.
Yeah. Well, there may have been a similar judicial development in Scotland, I think, to the extent that, first of all, the point Lord Clark makes, the debtor, the defender, would always be entitled to enter the proceedings to defend them. And even if ejection is sought, as it is here, that action proceeds as an ordinary action with all the procedural safeguards and steps available to the defender. And ultimately, in any event, it would have been open to the sheriff to supersede extract, that is to say, to postpone the issuing of the extract decree, which can actually be enforced for a period of that kind.
Yes.
But now we know that since 2001, the court in any event has been given a much greater express discretionary power to suspend the creditor's rights, depending upon the financial circumstances of the borrowers and the steps the creditor has taken to try to resolve the problems before applying to the court.
Well, we've had a long discussion about this particular
Yes.
point. Where do we go from here?
Well, perhaps I could simply refer to the opinion of the judgment of Sheriff Principal Kaplan and the passages in the opinion of the extra division. I won't read them because I think we've discussed.
Yes.
Unless your lordships wish me
Well,
to.
so-
Well, I haven't really absorbed Sheriff Kaplan since I've sort of got into the case. I just
Well-
wonder what he's saying.
Well,
Because that's
maybe-
what the division have accepted, isn't it?
Yes, because essentially the division have adopted
Yes.
Sheriff Principal's
And do we get all we need to know about that from paragraph 40 of the opinion of the extra division?
Yes.
This is a long quotation, I think, there.
Sheriff, perhaps if I could just begin with the judgment of Sheriff Principal Kaplan.
Or would you like us to look at it in the bundle?
That may be helpful.
All right, yes.
My Lord,
Let's do that then.
it's in volume 1 of the authorities. Tab 13.
Yes.
And just looking at the first page on page
Sorry,
7.
which page?
I'm sorry, tab 13, page
Thank you.
71.
No,
The-
thank
yeah. I simply draw to your lordships and your ladyship's attention on page 71 at letter F. The terms of section 29.2 of the 1970 Act as originally enacted, because that provided that any application had to be by way of summary application. That just gives context to the issues which are being considered by the learned Sheriff Principal in this case. I should also say that a summary application, again, still involved a full set of pleadings and procedure leading up to any trial or proof at which the issues were decided, but it's a more flexible procedure than the ordinary procedure in the Sheriff's Court. And we see immediately below that this was a case where, following upon service of a notice of default, that the creditors had raised an ordinary action against the proprietor, craving warrant to enter into possession and warrant to eject. And one of the issues with which your lordships and your ladyship were not concerned was whether the correct procedure had been followed, whether this should have been an ordinary action or a summary application. And Sheriff Principal Kaplan on page 72 effectively discusses and decides that issue and says that the case should indeed proceed as a summary application, and we see the conclusion as to that ends at the top of page 73, just above letter A.
So this was a case where the creditor chose to proceed under standard condition 9.1b.
9.1b, my lord, yes. My learned junior, I think, helpfully reminds me that if, having considered these passages, if your lordships go back to page 71 between letters J to K, they'll see this is a case where the default was non-payment of arrears due under the...
Yes. Between letters J and K.
Yes. Arrears of instalments.
And does the Sheriff Principal grapple with the problem we've been discussing about the relationship between 9.1a and 9.1b, or is he really dealing with the procedural issue as to whether they can proceed by summary process or ordinary action?
He had first been addressing that issue, my lord. At page 73, he then addresses precisely the issue we have been discussing this morning.
Right.
And he begins doing so just below letter A on page 73. And the first passage goes down to just below letter E.
Yes.
And then he goes further, as we can see, from just below letter E to letter H in the next column.
What was the default?
It was a failure to pay instalments of principal and interest due to the lender.
So this was a case where the entire debt was not yet due, but instalments were expected and had not been paid out.
I understand that to be the position, my Lord.
But does he consider the Section 19 mandatory point?
That wasn't an issue
No, I don't.
canvassed before him.
No. I mean, I get the impression that he's really struggling with the problem of the correct procedure to be adopted under the Sheriff Court rules, and whether it requires a separate action or whether it can all be done by way of a summary process or whatever else. And
That is the basis, my Lord, on which the appeal came before him. But I think your Lordship and your Ladyship will see that the learned sheriff principle does consider precisely the point that we've been discussing this morning as to what is meant by the provisions of Section 24.1 in putting a standard condition 9.1b creditor in the position where he or she can exercise the remedies of a creditor where there's been a default within the meaning.
Where is that, Mr.
Well, it's really just below letter D on page 73. If your Lordships and Ladieships see a passage beginning, if the pursuers had, and his Lordship says there, if the pursuers had been proceeding in respect of a default in terms of standard condition 9.1a, then in this case to take proceedings for rejection would have been a remedy open to them under the 1894 Act. If, as here, they want to proceed to exercise the remedy in respect of a default under standard condition 9.1b, then in terms of section 24, they can apply to the court to exercise the remedies they would have had if the default had been under 9.1a. But it seems that they must so apply to make their remedy operative. It can scarcely be disputed that a right to eject is a remedy. Moreover, it is a remedy which essentially requires the warrant of the court, for one cannot eject at one's own hand.
Yes.
And he then deals with the question of recovery of rents, and taking it up again, about 6 lines from the bottom, his Lordship says the ejection of the debtor is in a different category. By entering into a standard security, the debtor directly affords his own ejection as a remedy, and the remedy cannot be operated without a court application. That is why Section 5 of the 1894 Act expressly confers the right to take proceedings for ejection, just as the creditor cannot enter into possession where there is a 9.1b default unless he gets the court's authority under Section 24.1, so he cannot operate his remedy of ejection without an application under the same section. This is as it should be, for the two remedies are intrinsically interrelated. In most cases, the issue affecting the suitability of an exercise of the remedies of entering into possession and ejection of the debtor will be the same. If the debtor is in occupation of the subjects, possession of them is not going to avail the creditor much without free occupation, since there will be no rent to recover.
That's really all focusing on the fact that you have to go to court, because his main problem is, by what procedure do you have to go to court, isn't it?
Well, that is why the issue is before him, but the issue being before him, in my submission, he does very plainly consider the question of what remedies are conferred by Section 24, subsection 1, and what it means when Section 24, subsection 1 makes reference and defines those remedies by reference to the remedies open to a creditor who has served a notice of calling up.
One can see the starting point of his discussion at page 72, just below letter E, where he says, if the default, you see that just below letter E, entitles the creditor to require the debtor to discharge the secured debt, and failing that to exercise the remedies which arise on default, then the creditor, in terms of section 19.1, can serve a calling up notice.
Yes.
So he does seem to be proceeding upon the basis that there's a choice, and one route has one consequence so far as the proper procedure is concerned, and the other has another consequence, and he's trying to work out the way in which these two procedures should be reconciled, if at all.
Yes.
So it looks as though there wasn't any submission made to him. He certainly doesn't address the word shall at any point in this discussion.
No, there was no submission. No submissions appear to have been made to the Sheriff Principal as to the proper interpretation of Section 19(1).
He seems to proceed on the basis that the creditor can decide not to go by way of calling up notice, but can choose to go under by alleging a breach, if you like, or of 9(1)(b).
Indeed, indeed.
Do I understand rightly, Mr. McAfee, that if you're going under notice under 9(1)(b route, even if you issue a notice of default, and it's not opposed and so on, or if it's opposed and so on, then at that point all you get is the right of sale, foreclosure, and whatever the other six, whichever six is,
Repairs.
Repairs. Yeah. And but in order to get possession, you would still have to go to the sheriff. Is that right?
Indeed.
Under Section 24.
That is precisely the position. Well,
Yeah.
yes.
But he seems to say, without quite grappling expressly with it, that there would be power under Section 24 without, untrammelled by the proviso in Section 5 of the 1894 Act. Or at least nobody seems to have argued.
Nobody was arguing.
The point
that,
doesn't
was
seem
it?
to have arisen, really.
No. But yes, I mean, he's saying that the position of the Section 24(1) creditor is to be equiparated with the position of the Section 19 creditor who has served a notice which would comply in that case with the requirements of Section 5.
You say, well, this is perfectly fair, because when you get to the sheriff, by that time at least, which is before there's any possession, the the proprietor will have full notice of the position and can advance any substantive defence that they might have.
Well, indeed, yes. There's no question of the borrower being deprived of the opportunity to challenge the proceedings in any way or the entitlement to the remedies that are being
Say
sought.
that really the point being taken here is really a wholly technical one, namely that the notice wasn't given before the commencement of the proceedings.
Yes.
But if, on this approach, Sheriff Kaplan's approach, he'd still have the proprietor would still have their day in court.
Oh yes, there's certainly no way of depriving the proprietor of his or her day in court should they wish to challenge.
So in a way what's happened here is they've jumped to the other side, have jumped on the bandwagon, saying you didn't do this in time, and so you're stuck.
Yes, it's not disputed, as I understand it, that the partnership debts were called up some 18 years ago and no part of them has been paid in the interim.
Could you look, if we finish looking at Sheriff Kaplan, at the way, am I moving too fast? I was going to ask you to contrast what he says with Sheriff Principal O'Brien, quoted in paragraph 41, because the difference between the two seems to be related to appeal rights. And I'm not quite sure I fully understood this. Is there a difference as to rights of appeal between the two proceedings?
Yes, I think if I can ask your Lordship and your Ladyship to look at that section 29 of the Act as originally enacted, that is tab 2 of the first volume of authorities at page 22.
Yes.
They'll see there on page 22 subsection 3 of section 29.
Oh, I see. Yes.
And what the Act, as originally enacted, provided was that any interlocutor of the Sheriff disposing of an application under Section 24 shall be final, except as to a question of title. So that restricted, clearly, the rights of appeal which might be open to the borrower who had entered the proceedings to challenge the creditor's application for warrant.
So if you proceeded under Section 5 of the 1894 Act, that would be, the argument would be that it's a separate proceeding, which is under that Act and not under this Act.
Yes.
And therefore the rights of appeal, which are normally available, remain available.
Yes. But the position was then altered, as I say, by an Act of Sederant, which provided that applications under the Act where there was where a warrant for ejection or some other remedy was sought had to proceed by way of ordinary actions, so the rights of appeal became the same.
Yes, I see.
Otherwise, for the sake of... So that was the position that is the position, so far as we are concerned in these proceedings, that there is no restriction on the right of appeal, as we know. I think we wouldn't be here otherwise. But for the sake of completeness, I understand the 2010 Act, which came into force on the 30th of September, changes the position back again so that all applications in relation to the 1970 Act, whether they're Section 5 applications, 1894 Act, or Section 24 of the 1970 Act, they've all now to proceed as summary applications.
Yes.
But that makes very little difference to the procedure and the actions. It certainly doesn't in any way restrict the opportunities open to the borrower to challenge what is being sought.
On your construction of Section 24, is there ever any room for Section 5?
Yes, because service of a notice of calling up will entitle the creditor on its expiry without payment immediately to exercise the power of sale, the power of entering into possession, and various other powers conferred by Standard Condition 10. If the debtor fails to vacate, then that creditor doesn't require to apply to the court for warrant to exercise the Standard Condition 10 remedies. All he requires from the court is a declarator or declaration that he's already entitled to do that. He's not obtaining warrant from the court to allow him to do it. He's already entitled in terms of Section 21 to do that. So that creditor, on the expiry of the notice, if the borrower doesn't vacate, would raise an action under Section 5 of the 1894 Act, simply asking the court to declare he's already entitled to enter into possession and sell, and now the debtor should be ejected to enable him to do that.
And the order to leave wouldn't be a warrant?
Well, it would be a decree of the court. It would be a warrant in the sense that the warrant that's being sought here is a warrant. There would be no difference between them. It would actually be a warrant to eject. The decree would grant warrant to eject.
Yeah.
But it would be precisely the same as the order that the respondents seek here in seeking a warrant to eject. I don't know if
You wouldn't need Section 5 for that, would you?
Well, that creditor would be proceeding directly on the basis of Section 5 because he would have served a notice of calling up. He doesn't require a warrant from the court to exercise the remedies of entering into possession or selling. He's only requiring the assistance of the court in obtaining a warrant to remove the debtor, eject the debtor, in order to exercise these remedies he's already entitled to exercise.
So the kind of wording that you're suggesting to us you'd expect to find is what we see actually in the supplementary appendix at page 4. I think I'm right in saying that there is, of course, this is the present action which was asking for one to exercise other things in the first crave, but the second one is really a Section 5 crave, isn't it?
Well, the same wording could have been used for a crave in a Section 5 action.
Yes.
But instead of the first crave seeking warrant to exercise the Standard Condition 10 remedies, there would simply be a crave asking the court to declare that the creditor is already in that position.
Yes.
By virtue of the expiry of the notice of calling up.
Yes. And then you would have the second crave which would seek the warrant.
Yes, indeed, my Lord.
And then that's sufficient authority for the sheriff officer, if necessary, to go to the premises and make sure they vacate.
Yes, yes.
That would be an action of ejection.
Yes.
It would, yes, Lord, yes. But I understand that my learned friend has provided your lordships, I think, with copies of the style that my Lord Roger had wondered might be available. Maybe helpful just at this stage to have a look at the style for the action of declarator and removing, because my learned friend contends that the appropriate remedy is removal. But just if we're dealing with the question of how the substance of what is in dispute as opposed to the technicalities, if we look at the extract that's been provided from Green's Encyclopedia of Scottish Legal Styles, I think the relevant style is number 13, which is on page 14 of the photocopy. If your lordships and my lady have that, on page 14 they'll see that style 13 indicates that the pursuers crave the court to find and declare that in terms of the disposition granted by the defender in favour of the pursuers, And then after reference to subjects, it says that the defender has forfeited his right to possess or occupy the said subjects, and that the pursuers are entitled to enter into possession thereof and to administer and let the same. And it then goes on to say, to ordain the defender summarily to flit and remove himself, his family and dependents. So we see already a reference to summary. This may be removal rather than ejection. The only summary part of summary ejection is the ejecting itself. It's not the procedure leading up to it. And here is a removal where the court is being asked to ordain the defender summarily to remove himself, his family and dependents, goods, gear and effects forth and from the said subjects, and to leave the same void and read, that the pursuers or others in their name may enter thereto and peaceably possess and enjoy the same, and that under the pain of ejection. So, whatever the wording of the crave, the practical effect is exactly the same. But the other thing I should draw to your Lordship's attention is that this appears to me to be a style for use where the form of security involved was what was called an ex facie absolute disposition in security. Because we were discussing yesterday principally the bond and disposition in security, or a cash credit bond and disposition.
You can see that in paragraph 2, actually, of the condescendence.
Yeah. Because as my Lord Hope's indicating, the difference is the bond and disposition in security, the borrower, the proprietor, remained with title to the property. They were the registered proprietor. This is a style dealing with the quite different situation where the proprietor actually conveyed title to the creditor, but qualified by a back letter indicating that the conveyance had been in security only. Now, one can well see why there might be a requirement for a declarator in those circumstances, given the qualifying back letter, but that is not the situation your Lordships and your Ladyship are facing, because the situation under a standard security is analogous to the situation under a bond and disposition in security, not an ex facie absolute disposition. So we will hand up to your Lordship and your Ladyship, if it would be of assistance, subsequently, copies of the styles from Dobie's Sheriff Court styles, which set out the styles for ejection and removal in normal circumstances. And your Lordships and your Ladyship will see that effectively, when the crave has been granted or resulted in a decree by the court, the defender or borrower is going to be ejected in either event. There's simply a difference in the label being attached to the proceedings.
Yes.
Sorry, I'm just going to ask you another question purely for my information. Why does anyone serve a notice of default, or does anyone do that? I mean, because it seems to me that in the end of the day, you're going to have to go to court under Section 24 anyway, to get the powers to get them out and all that sort of thing. What's the purpose? What advantages?
My Lord, as I understand it, if the property has been abandoned, one could serve a notice of default, because the period of notice is 1 month, or certainly under the version of the Act we're looking at. So that, if the property is abandoned, that is the quickest way to acquire the right to sell the property. So that might be used. It might be used where the relationship between borrower and lender hasn't broken down irretrievably, and the lender is content that if certain instalments are paid, the relationship should continue. But beyond that, it's difficult to know on what basis.
Do people actually use them? Yes, they are.
Yes,
they are used in these kinds of situations.
Indeed, I understand that. That's certainly the case.
Are they used for the examples given earlier of a breach of Standard Condition 6, for example, where the subjects are not being properly kept up?
Well, I understand the learned juniors indicating to me that rarely, but yes, a notice of default might be used where there's a breach of the repairing and maintaining obligation. But he's also, I think, quite helpfully indicating to me that very often the obligations undertaken in the security will be the borrower's obligation to build, because if money is being lent to a developer, the lender will want to stipulate for the particular development being proceeded with and perhaps being completed within a particular period. If the borrower then were to fail to adhere to those terms, the lender might well serve a notice of default indicating that unless, to the borrower, unless you get your act together and either start or accelerate the process of construction, we will enter into possession.
Yes. Well,
I wonder if I could ask one question about the condescendences here. I mean, in your condescendences, if that's the right expression, you pleaded a whole series of facts about the underlying indebtedness and so on. Now, all those would have to be proved before the court, would they?
Well, I suspect,
Subject to those.
I suspect most of it has been pled maybe in response to the numerous lines of defence that were being proponed by the defenders, because essentially the pursuers here were relying upon their Schedule 7 certificate. So the pursuers required to aver and prove that there had been lending and there was a default following upon a demand for payment, thereby bringing them within, I say, Standard Condition 9.1b. But as to the evidence of that, or the detail, the pursuers were content to rely on the certificate, which in terms of Schedule 7 to the Act is prima facie evidence of the default. So,
what was the defender's response to that?
On the question of the certificate...
Well, on the underlying merits, is it?
On the underlying merits, the defenders, at various points, I think, suggested that there had been misrepresentation by the bank manager, that the debts had become time-barred, that they weren't liable for certain debts. I mean, my learned friend will be in a position clearly to explain all that more clearly, but what one would see on page 20, if your lordships and your ladyship go to page 20 of the appeal print.
yes.
They'll see the pleas in law for the first defender, and those are the pleas in law are the succinct legal propositions being relied upon by a party to proceedings. I see, in fairness, that that there had been a plea of misrepresentation that had come out, obviously, by the stage of the pleadings. As a result of being repelled by the second division when the case was first before the inner house. So I think to answer my Lord Clerk's question, if your Lordship has seen the pleas in law which are set out here, it's quite clear, I suggest, that a very large number of issues on the merits of the bank's claim were being canvassed before the court, and that the defenders had a full opportunity to do that.
But the Sheriff tells us in his judgment, which is at page 160 in the appendix, that by the time the case reached him, many of these pleas were no longer insisted in. So the issues had shrunk considerably by the time he was examining the case.
Well, yes, evidence wasn't led in support of all of these pleas, but I'm simply, the only point I was seeking to make was that we can see that at various stages of the proceedings, the defenders have had the opportunity to propone very many lines of defence.
Yes.
Yes.
Right.
But I quite take my Lord Hope's point that by the time we got to the proof, the issues by concession had been narrowed quite considerably.
Well, where do we go from here then?
Well, I think I just refer your Lordships to the passages in the opinion of the extra division, which I rely upon.
Yes.
Which are on page 10 of the appendix in the core volume, beginning on page 10. And it's really the passage in paragraph 42 which summarises the reasoning which led the division to the conclusion that the respondents were entitled to decree in terms of the second crave of their writ.
Yes.
And what your lordships and your ladyship will see, I think, is that very largely the division has adopted the reasoning of Sheriff Principal Kaplan.
Yes.
And in my submission, we're well founded in so doing. If I could say by way of a side note that the point was raised by my learned friend that the division might be understood as having indicated at some stage that a Schedule 7 certificate was equivalent to a requisition under the Section 5 of the 1894 Act. That is not a submission I make, but nor was that in any way an essential part of the division's reasoning, because they expressly adopted the reasoning of Sheriff Principal Kaplan, and the mode of proof for the fact that there was a Schedule 7 certificate features not at all in Sheriff Kaplan's reasoning. I do suggest that one could perhaps read those passages in the opinion of the extra division as simply attempting to illustrate that the Section 24 creditor is placed in the same position as a Section 19 creditor. But if it's necessary to consider distinctly the question of whether a Schedule 7 certificate saying that, which is prima facie evidence, amounts to requisition, I don't support, I respectfully can't and don't support the reasoning of the division on that point.
Thank you.
Well, Lords, I'm conscious that I've probably taken slightly longer than I'd intended in addressing your lordships.
Well, we've been asking you a lot of questions. It's been extremely helpful.
Perhaps I could just briefly consider the question of whether removing is the correct remedy. For all the reasons I've submitted to your lordships, of course, I say that on the basis of the analysis which I'm offering to your lordships, the basis of the analysis which was accepted by the extra division, it's quite clear that ejection would be the correct remedy. But I also say that it doesn't appear in my submission that it is by any means clear that if I'm wrong in that, a creditor in the position of these respondents would be entitled to raise an action of removal. The authorities don't, in my submission, appear to be clearly to that effect. And if I could just take, my lords and my lady, as briefly as I can, to three of the authorities which were in my learned friend's additional bundle. Oh, sorry, one is in the additional bundle, the others are in the original bundle. So if I start with volume 1 of the authorities at tab 19. And that is the case, the report of the case of Ingles trustee against Macpherson.
Sorry, what point are we on now? I'm sorry to be rather slow, but
I was going to suggest that if your lordships are with me in my primary submission, then it would be clear that ejection must be the remedy that is conferred on the creditor. But I say that there were obviously submissions put to your lordships and your ladyship yesterday that removal is the appropriate remedy. And the point I simply seek to make at this stage is that I say it's by no means clear that removal would be an alternative that would be open to the respondents in the circumstances here. And I propose to try and illustrate that, if I can, by brief reference to three authorities.
I wasn't sure that Mr. Summers was making that point, actually. I wasn't sure that he was really saying you'd chosen completely the wrong remedy. I think the question really was whether you'd set up the basis upon which you were entitled to a degree of ejection.
I may have misunderstood my learned friend then, my lord. I had thought he'd gone further in this appeal by saying that the appropriate remedy was in fact removal. But if I've misunderstood him on that point, then I needn't address
I think it's probably my fault. I was suggesting that there was an alternative way of putting it on behalf of the bank, namely a declarator and removal. That's the point, is it?
Yes, but I had understood. I quite understand that my Lord Clerk was, I think, concerned to try and clarify what the remedies, the potential remedies might be. I had understood my learned friend to suggest the appropriate remedy here was removal rather than ejection, but if that's not the case, I needn't trouble your lordships and your ladyship with these authorities.
I thought it accepted that it would be within it would be a Section 5 case, and his point was that was reliance upon the proviso.
Well,
my note was that these authorities were cited to show how Section 5
Well,
had innovated on the procedure.
Well, in that event, I need
So
to trouble-
it's providing,
Yeah.
what it was doing was providing something that wasn't there before.
Yeah.
The older cases suggested you would have to, indeed, as you're saying, go by removing, but now you've got Section 5, which permits the summary process of ejection.
Yes. Well,
And that, I think, was the purpose of these authorities.
well, if that is the case, and the only point I would have been seeking to make was that it wasn't by any means clear that removal would have been an option open,
Oh, I see.
then I don't think I need trouble your lordships by taking them to those
I
authorities.
mean, my point was that let us suppose that they're right, then that can't leave the bank without any remedy, and that there would have been a remedy, or maybe there is a remedy, of declarative stroke removal. And I'm wondering why that isn't available now on the basis of the pleadings, since all these facts seem to be pleaded out. And are you not, in essence, asking for a declarative stroke removal?
Well, I'm asking for a decree which would have the same effect.
Right.
Yes.
So if you're looking at the substance of the thing, are you not in fact asking for that? You've given every conceivable notice to the wives now, or at any rate by the time it came before the sheriff.
Yes.
They've had every conceivable chance to run any point they wanted, whether in relation to the structure of the statute or on the merits of their case. And so they've had their opportunity.
Yes.
So why aren't you now entitled to a declarative stroke removal?
Well, the reason I wouldn't, as the pleadings currently stand, be entitled to that, I'm afraid, is that there is no crave seeking declarative and removal.
Because it wouldn't help you if it turns out that it isn't a Section 91B point, it's a Section 91A case and you didn't serve the notice.
Yes.
You presumably would be stuck because you hadn't served the notice.
Yes.
But subject to that, speaking entirely for myself and knowing nothing about Scottish procedure, I would have thought that there's no reason why you shouldn't have a declarative removal, at any rate in substance. But since you haven't, you accept that you haven't sought that remedy, and that's the end of it.
What is, my lord, I did give consideration to that, and I didn't think I could fairly...
There's not a sort of general principle that it's never too late to amend.
Well, I may have applied
I mean,
it.
history suggests there have been cases where amendments have been made up to the very last moment. At any rate, you're not making any such application.
No, I did give consideration to that, my lord. I don't consider I could fairly seek to amend my craves at this stage.
Perhaps unfairly then.
The position would be, of course, that I'm urging your lordships and your ladyship at least to find that the division were quite correct in taking the view that the respondents were entitled to decree in terms of the first crave of the writ, and therefore are entitled to exercise their power of sale and entering into possession and so forth. If further proceedings become necessary as a result of your lordships and your ladyship's determination on the second crave, then I think we leave that for another day.
I mean, the way the crave is put in there, and to understand what you're doing, I mean, it asks for the power to warrant to exercise all these powers. And then the second crave is to grant warrant to summarily eject. Now, is that sort of running two things? I mean, if you get the first one, then I'm just looking at it technically. What you would be what you'd be put into a position where you could take proceedings to eject. Is that right? Under Section 5.
Well,
I mean, are these? I mean, have you sort of? I mean, I'm not. It's not criticism. I'm just trying to understand exactly what's going on.
Yes.
I mean, is the second part really saying, well, these are proceedings to eject? You know, if you give us warrant, then these are the proceedings to eject. Is that right?
yes. Yes,
Is that right?
yes, my lord.
But I wasn't quite sure from what you said just before the question was put to you, whether you're saying that in any case you're entitled to decree in regard to the first crave.
Yes, well, simply seeking to indicate that this is an appeal against the interlocutor of the extra division by which they disturbed the learned sheriff's interlocutors by first granting decree in terms of the first crave and secondly granting decree in terms of the second crave. I was simply making the point that these two craves are separable and that it might be that one party succeeds in relation to one and one succeeds.
Did you ask for the second one? Yes.
Yes, ma'am.
You did.
Where would we find those?
The craves, my lord.
Well, the order of the interlocutor, I should say, shouldn't I, of the sheriff.
Of the sheriff.
No. precedes his judgment, doesn't
Yes,
it?
it
And
does.
it's
Yes.
at page, well, he's really, it's page
23, is it?
158. 159 is where he sustains the pleas and assoilies the defenders from the craves in the plural. So this page 159 is the interlocutor.
Yes. And then, yes, I'm obliged to my Lord Hope. And then we find the divisions, the interlocutor pronounced by the extra division on page 198
Yes.
and 199.
And they, at the end, find that the pursuers are entitled to the warrants as craved, both of them.
Yes.
And my point, the root point of my question really was: do these two craves stand or fall together? If we're in your favour, obviously we go back to the sheriff, and I beg your pardon, we. Yes, we do.
Yes. Well, I think I would suggest, my Lord, that the second is dependent upon the first, but the first is not dependent upon the second.
Yes, right.
Yeah.
The second crave is dependent upon the first, but the first crave is not dependent
Yes,
upon.
yes.
I mean, has the division, I mean, how did they decide that he should be objected? I mean, what consideration was given for that?
It wasn't put to the division. It wasn't put to the division. My learned friend will correct me if I'm wrong on this, but my recollection is it wasn't put to the division that there might be some remedy other than ejection. It was simply being argued that the bank hadn't brought themselves within the terms of Section 5 of the 1894 Act.
And it wasn't, I mean, was it accepted that if you were entitled to exercise the right to raise proceedings or ejection, that these were these proceedings and that there was no defence to those?
Well, that was my understanding, but again, my learned friend will obviously have an opportunity to...
So that must be the basis, is it on which the division...
Well, yes, because that's why, Your Lordship, will see there's no reference to discussion of different forms of remedy or... I mean,
No.
they have proceeded on the basis, as I understood it, but I do say, subject to what my learned friend has to say, that what was being submitted was there was no right to eject, but it wasn't being disputed that if there was a right to eject, ejection was the appropriate remedy.
and justified in the circumstances?
Yes, it wasn't suggested that there would be grounds otherwise on which it wouldn't be justified.
Yes.
My Lords, that brings me certainly to my final chapter of the submissions, which is simply to set out the four principal submissions on which the respondents rely. But I can do that shortly by simply indicating they are set out in writing in paragraph 27 of the respondent's written case.
Yes, your summary of reasons.
Yes.
Yes, and I think you've explained how they all fit together in the argument.
Well, I hope so, my Lord.
Yes.
I've attempted to, at least, I think.
Yes.
My Lords, in that case, I simply renew the formal motion which I made at the outset of my submissions, and unless there's anything further on which I can assist your Lordships and your Ladyship, those are my submissions.
Thank you very much indeed.
I'm obliged.
Mr. Sheridan. Thank you. Mr. Summers.
Lord, I think I should supply the clarification so that if my learned friend wants to address an argument about the difference between removing an objection, he should get the opportunity to do so. Now, my submission was that there was an alternative route apart from Section 5, which was removing somebody who had title and thereafter seeking ejection. And I think my learned friend wanted to, as I understand it, advert to the authorities that I cited in that connection. And if he wishes to
encouraging us to have a look at these authorities, are you?
I am not encouraging that, my Lord, but it's seeking to be fair to my learned friend. He was asking how my Lord had understood my submission. And what I'm clarifying is that I was suggesting that there was another route. at common law by which this remedy could be obtained. So,
Why can't it be remedied? Why can't it be obtained now? Apart from the fact they don't seem to be asking for it.
well, that's the first first reason. Is that ordinarily in Scottish procedure, my lord, if one is seeking a remedy, one would expect it to be focused in the pleadings.
I follow that.
And that's
But
really,
let's assume it's never too late to amend. Because we've got it all. We've got all the facts. We've got all the condescendences and the pleas and the saying knows what.
well,
Your clients don't seem to have any defence to the underlying materials, do they? I mean, they haven't really advanced one.
well, I did seek to indicate that one of the reasons why the way in which this has unfolded is prejudicial to those for whom I act is the order in which things have unfolded. I did complain briefly about the 3-year gap that intervened between the notice and the raising of the action, and I did complain again that meanwhile 25% interest is accruing, that the debt is completely unsustainable now for these people. However, if matters had been followed properly, and that the wives had been told up immediately and up front what the position was, I can't give evidence about these things, of course, but I'm absolutely certain matters would have followed a different course.
I mean, they don't seem to be seeking it, so there we are.
So, well, indeed, there we are, yes.
Well, on the arguments themselves, is there anything that you want to add by way of reply?
No, I think if I were to launch, I would be launch into things. I'd just be repeating what has already been fully canvassed. My Lord Walker asked for copies of the propositions in written form, and I have those to tender.
Thank you very much.
I hope they're as close to what I said on my feet yesterday as I can possibly make them. But no, my lords, I have nothing further else to add.
Thank you very much.
Well, we're extremely grateful to Council for their submissions yesterday and today, orally, and also for the materials we've been given in writing. We will take time to consider our decision.